Good morning. We're gonna wait a few minutes for everybody to be able to get in, and then we'll get started.
Sounds good.
We're just gonna wait a couple more minutes for more people to join, and then we'll get started.
Good.
Hello, everyone. I'm Jill Thompson with Optimum Re. I'm the AVP of Underwriting. I know there's more people coming in, but I'm gonna make some announcements before Monica starts. So our underwriting seminar has moved. It is now March 10th through 12th. If you haven't gotten an invitation, please email us at info.us@optimumre.com and we can have an invite sent out to you. We have a lot of really good speakers, so I'm really happy with the lineup. So hopefully everyone else is as well. Um, we do have an innovation webinar on March 26th at 11 a.m. Central Time. Jean-Marc Fix and Jane Wang, who is the CEO of Optimity, which is an award-winning wellness engagement platform. They're going to talk about turbocharging, I cannot say that word, the value chain through the use of innovation. And then, of course, brand new this year, hot off the press, is the claims seminar, which is very similar to the underwriting seminar, but Monica and her team will be putting on a seminar in October, the 6th through the 8th. So be on the lookout for the save the dates and the invites to that. We're real excited about it. Monica's got some really good speakers lined up already, and we're excited.
Yeah.
All right, now through the webinar, please put your questions in the Q&A, and Monica will answer them at the end. And any we don't get to, we'll send out the replies with the PDF version of the presentation. There will be a survey after the presentation, so please fill that out. That helps us to determine, what we want to do, continue to do well, what we need to improve, and also what other subjects you are interested into listening to. Um, and then everyone is muted. All the questions need to go through the Q&A. The chat doesn't really have the Q&A, and so please ask them in the questions. I think that is about it. So I'm going to introduce our speaker, Monica. Monica Clink has been in the insurance claims industry for over 28 years with experience in life, DI, critical illness, annuities, and hospital indemnity claims. She is currently the Vice President of Claims at Optimum Life Reinsurance in Dallas, Texas. Monica is very involved in the International Claims Association, or ICA. She was previously the secretary of the ICA and is currently the vice president of this ICA, and also participates in its education committee and its reinsurance committee. She is originally from New York and holds an MA in economics from Syracuse University. Welcome, Monica.
Okay. Thanks, Jill. And thanks everyone for joining us this morning. We really appreciate it. So today's topic, we're talking about claim adjudication, but we're going to look back. We're looking at the underwriting file. We're looking at the application and how it really influences the claim adjudication. So as my title indicates, we're going to look at the good health statement, conditional receipts, and beyond. So the agenda for this morning includes looking at the contract itself. What actually makes up that contract? What are the requirements? We're going to look at some barriers that we have to deal with at claim time. Insurable interest, which is always a hot topic. The good health clause statement, however you want to refer to that, that's actually on the application. That is a part of the agreements and declaration part right above the signature. So we're going to take a look at those. We're going to dive into temporary insurance agreements and conditional receipts. They can be different. Then we're going to take a brief look at the statement of good health upon delivery. Look at what kind of questions are on there. Take a look at reformations and do a recap and Q&A. So let's just get started. So the life insurance contract, you have to have three things for this contract. You have to have the offer, acceptance, and consideration. So let's break this down. The offeror is the person making the offer. And for this topic, a person legally can also be a company. Okay, so a person could be a body and it can be a company. So the offeror is the person making the offer, and the offeree is the person to whom the offer is made. So in a life insurance application, the applicant is making the offer, the applicant is the offeror, and if the offeror is making that offer to the insurance company, the direct carrier, the offeree. So what can the offeree do? They can accept the offer. Each term has to be accepted. Okay, that is an acceptance of the entire offer. They can reject the offer. It could be a decline. They can make a counter offer saying, oh, we'll consider it. It would be a, table 4. It's not going to be a standard. That would be a counter offer. When that counter offer is made, the roles switch. So the direct carrier insurance company, they're now the offeror to the offeree, the applicant. Okay. So those are the parties to the contract, but for sure, there has to be consideration. Consideration for a life insurance contract is premium. And we'll see through this presentation when that premium is really important when it comes to a claim. So again, offer, acceptance, and consideration. The acceptance must be communicated. Okay, it really shouldn't be implied. Silence does not necessarily indicate acceptance. However, we have seen some courts in cases where they've held that failure of a life insurance carrier to act on an application within a reasonable time does indicate acceptance. So we have to be very mindful of workflow and when correspondence is sent, when decline letters are sent. Just as in a claim, the underwriting part is very important. So let's get into an example. Okay, here's a $1.5 million policy that lapsed in January last year. There was a reinstatement application and premiums that were sent to the direct carrier, and they were received on February 16th, same year. But however, there was no communication to the owner or the insured, and the carrier did not return the premium. And of course, the claim, the insured died in April. So there was no correspondence back and forth. The premium was sent in. Was it reasonable? Did the owner insured have reasonable belief that they were covered? Probably, right? The consideration was there and nothing was done on it. Okay. So in a court case, sometimes they would say, yes, it is reasonable to say that the expectation had been met, that there was coverage. So we have to be very careful of, when we get the premium, if we shouldn't have the premium, we've got to return that premium. Let's go on to barriers. So barriers to a contract. So you could have offer, acceptance, and consideration, all those three factors that are needed for a contract, but still there might not be a valid contract. You have to have legal capacity. So in the event that there's incapacity, the contract is voidable by the incapacitated. Okay, so they could void the contract. There could also be lack of consent. So the offer and acceptance has to be made willingly, knowingly, without coercion. If there was, again, it's voidable. So what happens if there's a claim? Especially if a claim has been made when there's lack of consent, when the offer or acceptance was made unknowingly. Okay, so if a claim is presented and the direct carrier pays the claim without knowing any of this, without knowing possibly the applicant did not know about it. Okay, if they didn't know about something, if they didn't know if the person was incapacitated, if they had no knowledge, they can't be held liable. But they pay the claim, right? They pay the claim to the person to whom they think it's payable. And someone else comes forward and says, wait a minute, there was lack of consent. This didn't happen. There was coercion, whatever. The insurance company has paid that claim. It's now the other parties that now have to hash it out. Okay, so the insurance company does not get dinged for the not knowing, right? And that also comes up in, maybe a divorce issue, when possibly at claim time the divorce situation was not known for whatever reason. I don't know how that could happen these days. Most death certificates have, the marriage situation on the death certificate. Sometimes it's on the claim form. Most insurance carriers would know if the insured was married or divorced at claim time. But in the event that they didn't, I'm getting off topic, but it's kind of the same thing, because we're not dinging the insurance company for knowledge. So if the insurance company didn't know that there was a divorce, and they make a payment, they made the payment. They may not have to make that twice because they didn't know, right? They didn't know about that. And this is the same kind of situation. If they didn't know that someone may have been incapacitated, they're not held liable. It's not like they'd have to pay it twice. It's now an issue between the two parties who don't agree to it. So knowledge at claim is very important. If the carrier knew, if they had any knowledge that the applicant could have been incapacitated, that's a legal issue. Interplead, whatever, because you don't want to have to be liable twice if you have that knowledge. So if you don't know it, you wouldn't be liable. If you do know it, interplead it, talk to your counsel, get some help on it. Okay, so let's jump into insurable interest. So what is it? Insurable interest is the foreseen financial loss or other hardship when the insured dies. That person has insurable interest, and it is public policy. It must be proven at underwriting time. And then if it's changed later, it does not have to be proven later. At underwriting time, at the time of contract, it has to be proven. Why? Well, it prevents wagering and benefiting in the event of death, right? If there is no financial hardship or loss when someone dies, someone might benefit from it. If there's no loss, they're going to benefit from it. That the person would be more valuable to them dead than alive, right? With insurable interest, the person is more valuable alive than dead. You know, it's spouse. Let's take two spouses, and one spouse works. So the working spouse is very valuable, you know, for support when that spouse is alive. Okay, so there's insurable interest. You know, with children, there's going to be insurable interest with close relatives. Now, I put some examples here that could be totally a different topic for discussion later on, but equally important are viaticals, doles, those are stranger-owned life insurance, where there is no insurable interest, right? Viaticals happened a long time ago. Then they were taken out, very ill folks, and they were wagering that they would die early. Okay, of course, they would benefit from the death early because they're paying premiums, betting the person's going to die. If they're not well, they basically want them to pass early so they can benefit and get the proceeds. Stolies are kind of the same way. You know, it's got stranger owned, and they're paying the premiums. The fewer premiums they have to pay and get the benefit, the higher the profit for them. So they are strangers who own these life insurance policies that get the benefit, and it's a type of wagering because they are more beneficial to them if the insured dies than when they're alive, right? Because when they're alive, they have to pay premiums. If they're dead, they get the benefit. Okay, so insurable interest, you know, stops that because we can't have wagering. We can't have benefiting in the event of death. I put something out here about Slayer statutes, and I wanted to mention that because you could still have insurable interest and still benefit from someone's death. I know it seems odd, but there are people out there. We have seen the claims, which there is an insurable interest, and the beneficiary had something to do with the death of the insured, and they benefited from the event, or they could have, but then it was found out that they had partaken in that, and they can't. Again, it's public policy. They can't benefit from the death. So they had insurable interest. They tried to benefit from the death, and of course they get caught. But that could be a different topic. But I did want to put that in there because they have insurable interest, but they're trying to benefit from the death, and they get caught. Okay, so let's go a little bit deeper into insurable interest. So if the policy owner and the insured are different, so basically somebody is taking a life insurance contract out on somebody else, okay, then both the owner and beneficiary must have the insurable interest and prove financial loss and hardship when the insured dies, okay? The applicant owner must benefit from the continued life, not the death of the insured. So that's basically what I said before. That's insurable interest. You benefit more from that continued life than when they had died, okay? Now, the policy owner insured, of course, can be the same. You can take out a life insurance policy on yourself, and you have insurable interest in your own life. And you can name almost anyone as the beneficiary. When it gets really sticky when somebody else takes a life insurance contract on somebody else. Okay. So here are examples where insurable interest cannot be established, and therefore you can't buy a policy on those folks. Okay, so anyone who doesn't financially depend on you. It could be relatives such as aunts, uncles, or cousins. Could be. You could have, you know, one sole survivor cousin, and they're going to take care of your last wishes and your final expenses. You know, they're going to have some expenses, you know, so they could have insurable interest. By and large, though, they're far removed. Strangers, obviously. Strangers cannot take life insurance out on other folks, right? Your neighbors, you can't have insurance on your neighbors. You can't have insurance on your coworkers. You just can't do that. Okay. You also can't take out, there wouldn't be insurable interest if there's excessive death benefits. Again, prevent profiting from death. And is it suitable? So, for instance, say my daughter took out a life insurance policy on me, for, I don't know, $500,000. Well, all I would ask for her at the end, if I should pass, is to take care of my funeral. So, maybe there's some other expenses, but I don't think there would be $500,000. I don't know if that would be suitable for my daughter to have a life insurance policy on me for $500,000. She would profit from that. Okay. Okay. So a contract on one's own life. I pulled some information from the ACLI, and this is what I said before. An individual may procure an insurance contract upon his own life or body for the benefit of any person. So basically, you're taking out the life insurance on yourself, and you can name almost anybody as the beneficiary. And that's majority of the states. Of course, I didn't list them all here, but the big states: California, Florida, New York, Oklahoma, Texas. If you are the owner of your own life insurance policy, you can name almost anyone as the beneficiary. So here's just a little bit what California says. An insurable interest must exist at the time the contract becomes effective. That's what we've been saying, but need not exist at the time of loss, right? So the contract is made, there's insurable interest, and for some reason, there could be a beneficiary change or whatever, ownership change. It doesn't need to exist at the time of loss. Any contract of life or disability insurance procured is void unless the person applying for the insurance, the applicant, has an insurable interest in the individual insured at the time of application, right? So that's two different parties. That's the applicant, say the owner, and the individual insured. There's got to be insurable interest. Otherwise, it's void. New York goes a step further, okay? They say, and I'm in the second bullet here, nothing herein shall be deemed to prohibit the immediate transfer or assignment of a contract or procured. If benefits are received from an insurer that violates insurable interest, then the person insured or their executor or administrator may bring action to recover benefits from the person receiving them. Again, not the insurance company. Okay, so the first bullet, that means there's insurable interest. You named a beneficiary, you had your own policy, you named a beneficiary, then immediately transferred it, sold it, signed it to somebody else. You own that contract. You can do basically with it whatever you want. So that's what New York State says. You own it, you can do that. If you weren't the owner, that's a different story. Okay. The second bullet basically is saying that, if the benefits are received and then it's known that there was an insurable interest, then the two parties bring action against themselves, not the insurance company. In any doubt, if there's any doubt that it could violate insurable interest, then the carrier would be going to interpleader. But in the event that they don't know, something like that could happen later. And we have seen that happen later, absolutely, where payment is made and then it comes up that, wait a minute, this person didn't have insurable interest, and then there's a suit against the other party. The insurance carrier is done. They're out of the picture. They don't have to worry about it. I gave this example for New York. This is the Kramer versus Phoenix Life, and this is the case that really highlighted that issue, that when a person owns their own contract, their own life insurance policy, then they can immediately transfer it without insurable interest, even when the policy was obtained for that purpose. Okay, because you own it, you can do with it whatever you want. So this is the case that really highlighted that issue with New York. Okay, again, this is from the ACLI. Thought this was interesting. These 4 states didn't have citations for insurable interest other than that regarding charitable organizations. District of Columbia, South Carolina, Tennessee, and Wisconsin. That doesn't mean that they don't, adhere to insurable interest. They just didn't have any citations. And I just thought that was interesting. So let's go through another example. Again, this was a claim. The owner and the beneficiary of a life insurance policy were listed as spouse. Right? A spouse has insurable interest on their other spouse, for sure, okay? The claim submitted 5 years after the policy was issued, so it's not contestable anymore. The beneficiary claimed as the spouse. Everything looked fine. When the death certificate came in, it was revealed that the insured was married to another person. So again, most death certificates show the marital status on them, and it'll show surviving spouse. And lo and behold, that was the surviving spouse. This person that took out the life insurance contract was not the spouse. Further investigation revealed that the insured had been married for 20 years. So claim disposition, there was the insurable interest possibly was not there. It was not the spouse. I would say that could be voidable at that point. So that case would be referred to legal department for further review, but insurable interest seems to have been violated by someone posing as the spouse who clearly was not the spouse. Here's another example. The proposed insured was also the owner and listed his ex-spouse as the beneficiary at the time of application. So said the ex-spouse was the beneficiary. Okay, so he was his own owner, could name anybody, and named his ex-spouse for whatever reason. And the divorce occurred months prior to the application. So, there is a lot of states rule on divorce and revocation of beneficiaries. So could this have been one? It could have been, right? So ex-spouse could have insurable interest. It could be part of the divorce settlement that they have to have a life insurance contract. It could also serve as financial protection for the ex-spouse and their children. So just because it has the ex-spouse as the beneficiary, I have to go a little bit further. Why? And it's probably because of the divorce settlement. Okay, here's a really good one. Maybe you folks have already heard about this. It was quite a few years ago. It was the Bergman case, Sun Life versus Wells Fargo. I'm just going to give you snippets here so we can see what kind of insurable interest issues were here. So there was a $5 million policy issued listing the insured's trust as the owner and beneficiary. So it had the person's name on it. So it seems bona fide that their own trust would be the owner and beneficiary. The insured's grandson was a trustee of the trust, but then resigned 5 weeks after the policy was issued. Okay, there were 4 other trustees, and they were basically strangers, and they were the investors. Okay, so it was fronted as there's insurable interest, it's the trust of the insured, and then the one person that's related, the grandson, leaves, resigns, and we're left with strangers owning the policy. They're the trustees and the beneficiary. Premiums were funded by the stranger investors. But there was also financial misrep of the insured's income and net worth. So I believe the insured was a retired school teacher and had misrepresented their income and net worth to make it more suitable to not just have a $5 million policy here, but other policies and large policies elsewhere. The policy was sold before the insured died. So the investors sold the policy and they received the proceeds from that sale, right? So this is, the third market. They're selling the product. They're selling it to Wells Fargo. They're selling it just like, your mortgage is sold. So Sun Life, when they get the claim, they refuse to pay the proceeds and declaring the policy void ab initio. Oh, typo, ob, it should be ob, from the beginning, since it was a Stoli scheme. So those investors, the original investors, were strangers. They paid the premium. They got proceeds. They sold the policy and got proceeds. Wells Fargo countersued for refund premium. It paid after it got the policy. So they wanted the proceeds, or the refund of premium, if the policy was void. So who would get the premium refund? So what really held up here? The courts held the policy was void ab initio, that it was a Stoli scheme. The owner and the beneficiary did not have insurable interest. It was a wagering contract, basically. they were waiting for this insured to die to get the proceeds. And the courts also held that, yes, Wells Fargo could get the refund of premiums they paid since acquiring the policy because they weren't party to the original procurement of the policy. Okay. So that was insurable interest really in a nutshell when you have a third party, investors paying the premium, applying for the policy, getting proceeds, and the person insured is just the vehicle of getting the proceeds. And in this case, the insured didn't die soon enough, according to schedule. I don't know, but they sold the policy and got proceeds instead. But then it was void ab initio. They would have gotten the proceeds anyway. Okay. On to the good health clause statement, and this is the part that's in the application itself. Okay, the good health clause is contained in the agreement or declaration. It's above where the insured owner applicant signs. There could be the authorization for MIB, all of that stuff. So sometimes it's a whole page in the application. States that the policy will not take effect unless the insured is in good health or some other language like that, or the same state of health as stated on the application, something regarding the health. This is what you want to look for, is something that relates to the health of the insured. So it states that the policy will not take effect until the insured is unless the insured is in good health at the time the policy is delivered and the first modal premium is paid. So those conditions would have to be met. So you're in the same state of health as when the policy is delivered and the premium is paid. It is subject to the 2-year contestable period. Can't rely on that outside the 2-year contestable period. And it really accounts for changes of health between the application date and delivery. So we have to be careful about this little clause in the application. And I've got some examples here. This insured had a MI and hospitalized for 2 days after applying for the policy and when it was delivered. So, excuse me, this person had an MI, was hospitalized, and all before the policy was delivered. So should the policy be delivered? No, probably no. Take it back. Don't deliver it. You're not in the same state of health. Obviously, you've been hospitalized. You had a heart attack. That should not be delivered. Claim disposition if contestable. Okay, so this was the first question was, should the policy be delivered? The agent may or may not have known. The agent could have been knocking at the door when the person was already hospitalized. But at that event, no, the policy shouldn't be delivered. If the person dies within the contestable period, then of course look at all the contestable medical records, and this could be relied on in most states, depending on if it's a causal state or whatever, that these conditions had not been met to state the policy would take effect. All right, if the person had an MI before the policy was delivered, then the second bullet here would state the policy does not take effect because the person was not in the same state of health when the policy was delivered. So if it's contestable, I would always go back there and say, okay, is that something that we should be looking at regarding that change of health? What if it's not contestable? Not contestable, you can't do anything about it. Probably won't get medical records. You won't know. So not contestable, can't do it. So the good health statement was part of the agreement declaration, whatever you want to call it, before the signature on the application. It is different from the authorization for MIB and prescription history check and all of that. It's different from that. It's going to mention, the answers are true and complete to the best of my knowledge and belief. It'll state that no agent or person can change the contract. It'll describe when insurance becomes effective, which we just saw. Sometimes delivery is a condition, sometimes not. And I believe I have a case where delivery is not a condition. And then we just went through that good health clause that is in there. And I would recommend that if there's an early claim right around that time of the policy being issued, that the application be really reviewed to see what events had to happen and almost in what order to be sure that policy was in effect. So let's go through this example. Okay, so example 1, there's no cash for that. CWA, cash with F, no cash. So then it states within that application, we agree, except as provided in the temporary insurance agreement, if advance payment has been made, and we'll talk about the temporary insurance agreements a little bit later. We agree the insurance will take effect only when, so 3 conditions here. Policy has been delivered and accepted. The premium has been paid in full during the lifetime of the proposed insured. Premium can't be paid if the person has passed. And believe me, I've seen that happen, or at least they tried to do it. They tried to pay that premium when the person has already been passed. And 3, the proposed insured remain in the same state of health and insurability as described in each part of the application at the time conditions 1 and 2 are met. So this basically says the same thing that the other one said, that the policy has to be delivered in the same state of health of the insured. Premiums must be paid during the lifetime of the insured, again, without a change of health. Okay, so what if you have a death before delivery? What if you have death before delivery? It basically says the insurance was not in effect. It has to be delivered. There obviously was a change of health, right? Death is the ultimate change of health. There would be nothing there to rely on. The insurance did not take effect. The person died before these conditions had been met. Death before the initial premium paid. Again, the same kind of situation. You have to have the premium and the policy being issued and delivered, same state of health. All of those things have to happen. So if the death before the initial premium was paid, you don't have that consideration going. Remember those slides in the beginning, consideration? You didn't have consideration. So if there's no consideration, there's no contract, there's no claim. Change of health prior to delivery and premium. Well, for both of them, I mean, that's obviously there's no contract again. We have to have that consideration. And if it was material change of health, of course, then there could be adverse action taken saying, okay, the policy didn't take effect, right? You have to have the policy delivered, premium has to be paid, change of health, again, material. I mean, a cold, earache, it has to be material to affect the insurability of the insured. Okay, so here's another one. Again, no cash for that. I agree to notify the company of any changes to answers given in any part of the application before accepting delivery of the policy. I like that. I like when it actually says, I agree to do something. Because then again, the signatures are below this. It'll be paragraphs below, but I like when it says, I agree to notify, because if you have to rely on that at claim time, then you can say the insured owner agreed to notify, and perhaps they did not. Okay. The second bullet, except as provided in the temporary insurance application and agreement. Again, that's when premiums are paid. Insurance will not begin unless all proposed insureds are living and insurable as indicated on the application at the time the policy is delivered to and accepted by the owner and the first modal premium is paid. Again, basically saying the same thing. They're all putting words in different orders, but they're using the same kind of concept that everything has to be the same situation as the application. The health has to be the same. Premiums paid during the insured's lifetime. So a claim, change of health prior to delivery and premium. Okay. You have to have the premium paid. Has to be your health has to be the same before delivery. So again, you rely on this clause on the application that states that the insurance wouldn't have taken effect because things had changed. And because the insurance company didn't know about those changes, they don't have to take that risk of the unknown. Okay, here's a little bit longer one. A couple of really good things in here. Of course, it says, I have read the completed application. I don't know how often that happens, but it's good that they are saying, I read the application. I am not under the influence of any drugs or alcohol that would affect my ability to understand and complete this application. I've never seen that, only in a couple ones. It's good at underwriting time to state that there's so somebody's not under the influence. At claim time, I don't know how easy or difficult that would be to prove, but it's good that that is stated there and the person is attesting that they're not under the influence. This next bullet, the application and any medical records shall become part of any issued policy. That puzzles me when it states medical records, because I've never seen medical records attached to a policy, actually attached and given to the owner. So that one puzzles me. But that would be for an attorney, I guess. But I've just never quite seen medical records and medical records attached to a policy. Except as stated in the conditional receipt, and we'll talk about conditional receipt. Again, it says no insurance takes effect until the first full modal premium is paid. All eligibility requirements have been met. The policy is delivered and accepted, during which the health of any proposed insured continues to be represented in the application. And again, this one sentence that I really like, it says, I agree to notify the company of any changes and answers given in any part of the application before accepting delivery of the policy. I like when they say, I agree to do that. This one, again, similar kind of language, but I bolded something because that was bolded on the application. And again, it's the thing that I like, that you have to notify of any material change in health or other risk factors taking place before policy delivery. So I like that it's bolded. It says material change, and it seems like we're leaving that upon the proposed insured or applicant to say that it's material, but it is bolded so that they understand that they have to reach out if there's any change. And I don't know how often that ever happens, but I do see it claim time when there's changes of health and nothing was done. The owner applicant never reached out. I do see that at claim time for sure. Okay, so this one, I understand that for the insurance to go in effect, the proposed insured's health condition must remain as described in the application at the time the first premium is honored by the bank and policy issued. So why I grabbed this one was it said honored by the bank. So most of the time, I'll see the language that says honored at first presentation by the bank, not just honored by the bank. So it's talking about the time frame. It's described in the application at the time the first premium is honored by the bank. So that could be a situation in trying to figure out when was it honored by the bank, and it's really being held to honored or honored upon first presentation. So what if the insured applied for insurance on a Friday night, died on Saturday, banks are closed, you're not going to get any kind of check clearing on that date? Could you accept this? What if the person died? Could you say that, yeah, we're going to accept this and we're going to review for claim? Or was this condition not met because you can't present to the bank? You're not going to have it honored by the bank for sure. Example 2, premium issued and policy issued and premium was honored, so we know that for sure, but they died before the policy was delivered. And what does this read? The proposed insured's health condition must remain as described in the application at the time the first premium is honored and the policy is issued. It's silent on delivery. It's silent on delivery. It just has to be issued and the premium honored by the bank. It doesn't have to be delivered. So that would be considered for review as a contestable claim. Okay, now this one, let's see, if the first full modal premium has been made and the medical information is correct, then coverage under the policy applied for will become effective immediately and remain in effect as applied for unless notified by the company that it's been declined. Okay, and the maximum amount of life insurance may become effective prior to the delivery shall not exceed $25,000. So there's a cap on that. So they're saying that as long as the medical information is correct and the premium is made, then it would be effective for $25,000. So here, insured applied for insurance, cashed with that Friday night. died on Saturday. Did they pay premiums? Claims decision. So the first full modal premium has been made. So I'm saying there's cash with app. They sent a check in. They did the authorization for withdrawal of their checking account, whatever, payroll deduction, however. They made that effort to say, yes, there's cash with app. Okay. So you would consider that as being paid. It's not stating that it had been cleared by the bank on that day. All right, probably later on, it'll say cleared at first presentation. Okay, but I would consider that because the first premium had been paid with cash with app, even though it didn't go through its clearinghouse or has been cleared by the bank. All right, if it doesn't bounce, then I would consider that for review for claim. Okay, so let's go into temporary insurance agreements. So the temporary insurance coverage is it's providing insurance while the insurance company evaluates the risk. Okay, and you're going to have terms, conditions in there. You might have a time limit. There might be a limited amount of coverage. There might be some questions that have to be answered in the negative. There could be, it'll state that there's a limit to a refund of premium if material misrepresentation or if the insured dies by suicide. These types of agreements can go by other names. They could be a conditional receipt. We'll go through like a real conditional receipt in a bit, binding receipt, temporary insurance application and agreement, but they all kind of do the same thing. They're providing some kind of coverage while the company evaluates the risk. Okay, so usually there's going to be some agent instructions. When can someone apply for this? When can you pay the premiums on an application? In this case, it specifically states, don't accept money if the application is over $1 million. Don't do it. Don't accept it if these questions could be answered yes. And these questions, could be a variety of different questions. But in this one, it is the proposed insured more than 70 years old? All right. If they are, don't accept it. Right. It's too risky. Does the amount applied for exceed $1 million? That was at the top bullet. Don't accept the premium. And then if the insured answers yes to these two questions, don't accept it. So these two questions, in the past 90 days, been admitted or advised to be admitted to a hospital, had surgery performed or recommended, or been advised to have a diagnostic test which has not been completed, or in the past 5 years been diagnosed, treated for, or advised to be treated for heart disease, cancer, stroke, or alcohol or drug dependence or abuse. Okay, so if any of those are yes or left blank, don't accept the money, don't issue a temporary insurance agreement. And I just want to mention questions that are left blank. So we have seen many applications in which answers are left blank. And, sometimes they're left blank for a reason because they can't answer it the way it's intended to be answered. Like, for instance, if it is supposed to be no, and they can't answer no, sometimes it's left blank with almost an implication that it could be a yes. But if it's left blank, you can't use it. Okay, so if you're not representing a yes or no, you can't claim a misrepresentation if it's blank. Okay, so a claim. What if premium was collected on $1.5 million policy application, or when the proposed insured is greater than 70 years old? What if premium was collected? Send it back. Send it back. From a claims professional, I say send it back. You don't want to be caught with that. Best practices would be to send it back. If you're not supposed to have the money, get rid of it, because you don't want it to be implied that the risk is there. Get rid of it. Okay. Here is an example taken right from an application here. It says, do not collect money, do not complete the temporary life insurance receipt and agreement if, and again, you got an age limit, you've got a couple questions that should be answered no, and it says about the amount of the insurance. The amount is applied for is more than 5 million or 10 million, so don't do it. So if you can say yes to a question here, or if you leave it blank, or if that's implied as a yes, or if you have a lot of insurance that you're applying for, or if you're a youngster or somebody more senior, then you don't get this. Okay, but All of these conditions have to be met. So not a lot of questions here to apply for this temporary insurance. Not a lot of questions, but they do have to be answered. So I go on into this temporary insurance agreement, and there's other conditions here, limitations that I just want to highlight. So all conditions have to be stated in the application. All conditions have to be stated and applied for when you are applying for this. So it has to be, all the questions have to be no. The age has to be, not a youngster, not a real senior person. There's a limit on the insurance. Okay. Applies to the total amount. The limited amount of the insurance on this agreement here is a maximum amount of $1 million for an individual and $5 million per survivor. So it is not the amount applied for. Okay, so let me go back. Here, the amount applied for could be $4 million as a single life or $10 million as a survivor, but the benefit is $1 million for individual and $5 million for survivorship. Okay, so the limit is smaller. It's a temporary insurance, but it is smaller. The limited amount applies to the total amount under this agreement and other ones with the company. So some people stack insurance. Some people will do insurance policies, list different beneficiaries for each policy for whatever reason, and saying that instead of saying there's 3 beneficiaries for this policy, there's going to be 3 policies and each has 1 person for whatever reason. So the amount payable is the total for all these temporary life insurance agreements. There is a limit for ADB, accidental death, and there could be exclusions. This one had exclusion for aircraft travel and voluntarily taking of a drug, medicine, or sedative. So not all the limitations and exclusions, but some of them. The date insurance begins tells you when the date would begin, when the application is completed and premiums paid. Again, premium, that's consideration. And this other bullet, this is what I referenced below. No insurance under the agreement will be provided unless the check or draft is honored when first presented for payment. Okay, so it can't bounce and then the insurance company tries again. It's got to be the first time. It still goes on to say like the termination and refund of premium. So when would the coverage terminate? All right, the temporary insurance is only for 90 days. It will terminate when insurance takes effect under the policy itself. You can't have both coverages. Or when the company mails decline, and then a refund will be made. The refund of premium would also be made without interest if the person died by suicide or if there's material misrepresentation. Other conditions. Oh, and let me go back. Material misrepresentation in the agreement. In the agreement is capitalized because if we go back to this was the agreement. Right? It doesn't say the application. It says the agreement. So we have to be very careful about that. What are we looking for if we're presented with a contestable claim, an early claim, and maybe there's coverage under the temporary insurance agreement? We have to see if material misrep is on the app or the agreement. This one said agreement. Other conditions, no one is authorized to change or waive provisions of this agreement. Okay, so this was the limitations on the agreement itself. Let's go through an example. Again, this is on the temporary insurance agreement. We have a 55-year-old female applying for a $3 million whole life insurance policy in Illinois. She paid the initial motor premium and completed the insurance agreement with a question. She died as a passenger in a motor vehicle accident 2 days after applying for the insurance and paying the premium. So she did what she needed to do. Okay. The contestable investigation revealed that 3.5 years prior to applying for the coverage, she had Guillain-Barré syndrome, which is the neurological condition in which the immune system attacks the peripheral nervous system. She still suffered from residuals, so she had neuropathy and weakness in her hands and feet. She had not been seen by a doctor since recovering 3 years prior to applying for coverage. So the doctor said, yeah, you're as well as you're going to be. You have residuals, and that's it. Claim disposition. Would she be covered under a temporary life insurance agreement? Specifically this one with those questions. Okay, so let's go back to those questions. So she applied for $3 million and she's 55, so she's not real senior. Okay, so she's within that age 15 to 70-year-old. She didn't max out the 5 million that would be needed. She died as a passenger in a motor vehicle accident. I mean, even an accidental death benefit claim wouldn't exclude being a passenger. Well, unless it was like the getaway car. I digress. I mean, very few claims would ever be like that they were involved in a felony. This one didn't even exclude felonious activity. So 3.5 years prior to coverage. So let's look at those questions. So the questions read within the last 24 months. And she was 3.5 years that she had neurological condition. And she said she hadn't gone to the doctor afterwards. She has residual. She hasn't been declined for insurance. She said she didn't go to the doctor. There's no routine checkups, no other concerns. She has weakness. She has neuropathy. And she's not residing outside the United States. So based on those questions, may not be much to rely on. Okay. So coverage under the temporary life insurance, based on the cause of death, based on the amount, based on the question, probably. For how much? Well, there's a limit. Remember, we've mentioned that there's a limit, which is maximum amount of $1 million. There would be nothing else really that mentioned why. She did everything she needed to do, and she was at the wrong place at the wrong time. So most people will say, well, that's what insurance is for. Yes. And does this happen often? Absolutely not. No, not at all. This does not happen. I mean, it can, but I probably don't see one that is quite like this, maybe not even once a year. Okay, let's go on with conditional receipts. They provide coverage from the date of application to the policy issue date if the insured was insurable. Okay, so this is a little bit different than the temporary insurance agreement. We didn't talk about true insurability. We talked about answering some questions, not insurability. Some courts found that the conditional receipts provide insurance coverage even if the proposed insured is not insurable. So applies temporary insurance to conditional receipts. That's really important. Okay, it's not priced like that, but courts have said it's reasonable expectation. I mean, if the conditional receipts are worded such that it's very clear that there would be coverage if these conditions are met, then hopefully the courts would say, okay, that's a true conditional receipt. If the proposed insured is required to undergo a medical exam which has not been completed before he died, then the basic requirements of the conditional receipt have not been met and proceeds would not be payable. So that's important in a conditional receipt. Again, there's more conditions here that have to be met. Insurability. Remember the temporary insurance agreement, there's a couple questions, not full insurability. So here's an example. No payment may be accepted if within the past 3 years, the proposed insured has been diagnosed, treated, tested positive for, or been given medical advice by a member of the medical profession concerning heart disease, stroke, cancer, HIV, or AIDS. The conditional receipt or conditional insurance may become effective as of the date the proposed insured completes the application in its entirety. The whole thing's got to be completed. Goes on to say about the effective date. Okay, it will take effect as of the effective date so long as the proposed insured is found to have been insurable as of the effective date, exactly as applied for in according with our underwriting rules and without modifications to plan, amount, or premium rate. Right? So go back to those first couple of slides and I was talking about the offer. The offer has to be accepted exactly as proposed. It can't be rejected. It can't be modified. There can't be a counter offer. It has to be exactly as it was applied. All the statements and answers are true. Of course, the first premium is received during the lifetime of the insured. That's the consideration. And the following have been signed and received if they're needed. Part 1 of the application is needed. any required supplemental applications, questionnaires, or amendments. So basically the whole file, like they have to follow the bouncing ball. They have to do all their requirements. There could be a limit, all right? Just like the temporary insurance agreement, this limit, the lesser amount of the insurance or $250,000. No conditional coverage for riders or benefits. Then it goes on to say that there's no coverage and the company's liability will be limited to return of premium if any of these occur. Proposed insured does not complete the application. All right, the offer is not made. The offer is not complete. One or more of the conditions have not been met exactly. Very important, all conditions have to be met. The insured dies by suicide, again, return of premium. And the company does not approve or accept the application within 90 days that the proposed insured completes the application. So no coverage if any of those happen. And then it goes on to say the termination. So when does it terminate? 90 days from the effective date, from the proposed insured completes the application. The date the company mails a notice to the proposed insured rejecting the application. The date the insurance goes into effect. Again, you can't have two at the same time. Or the date the company offers to provide insurance on terms different from the offer that was made. So that's the counter offer. So if a counter offer is made, then there's no conditional receipt coverage. So here's an example. Same kind of situation from before. I mean, really, this is the exact same one from the temporary insurance agreement. 55-year-old female, $3 million policy. Oh, and I'm sorry, I should have changed conditional receipt to temporary life, or other way around. So she completed the conditional receipt. And I will change that before the PDF goes out. The insured dies again within 2 days of applying for the insurance and paying the premium. So she did all she needed to do. Contestable investigation revealed the same thing, right? She had Guillain-Barré and she didn't see a doctor, but she had residual. Claim disposition. Would we consider this for conditional receipt coverage? Is there misrepresentation? Right. So remember, for conditional receipt, the offer has to be accepted exactly as it was, no modification. Would this insured still been eligible for maybe a standard if it was applied for standard? Was there material misrepresentation? You know, there were some questions on that application. Autoimmune disorder, other nervous system. So if there were table ratings, then there would have been no conditional receipt coverage because the offer would not have been accepted. There would have been a counter offer. So in this case, there wouldn't have been coverage because of the medical condition. Here's another example. No coverage would be effective prior to the policy delivery until all the conditions of the receipt have been met, and they're all bulleted. There's lots of conditions, right? So if the first full modal premium is paid, if all underwriting requirements, including medical exams, are completed, and the proposed insured is on the date of application a risk acceptable exactly as applied for without change of plan or premium against the same situation, you've got to be accepted without modification, without a counter offer. Then the insurance shall take effect on the latest of the date of app, the date payroll deduction authorization is submitted, that's cash for that, the requested draft date, a date of the last medical exam. So the coverage could start at the latest of those dates. And this one had in caps, which is nice to see, either bold or caps, you know, the limit. There's a limit of $200,000 of this conditional receipt coverage. Okay, so let's see a claim example. $400,000 applied for by a 58-year-old male. Paid the first premium and was issued a conditional receipt. No exam was needed. Proposed insured completed all requirements. So he did everything he needed to do. Okay, and it was just in underwriting. He died in a boating accident prior to the policy was delivered. The contestable claim investigation found no material misrep other than it had not finished going through the underwriting process. Claim disposition should have been paid. well, if you had accepted it and there was no counter offer, premium had been paid, no material misrep, that's a payable claim. Oops, but there's a limit, right? You don't pay 400,000. This one had a limit of 200,000. So everything fell into place, but the policy had not been issued yet, it wasn't delivered, limit of 200,000. Okay. So the statement of good health upon delivery. Sometimes an insurer will request this, and it does a couple of things. It prevents disputes about when the policy was delivered. So we talked about quite a few clauses in the application which talk about delivery. You know, sometimes a delivery has to be made. We saw one clause where delivery didn't really have to be made. Verifies the statement of health in the event of delays in underwriting. So you want to make sure you refresh it, make sure that everybody is under the understanding that there's a meeting of the mind. This person, you know, did not have a change of health, and it protects both the owner and the company. So a typical statement of good health upon delivery could read something like this. I declare that I'm in good health and that since the date of my last exam or declaration in lieu of exam for insurance, I have continued to be in good health. Good health, that could be a little bit subjective, but for this, we'll move on. When we're just saying good health, it's not really definitive there. I have not applied for any insurance which has been declined, postponed, or modified. I have not consulted or been examined by a physician or practitioner. So that's a good statement there, because that could be all encompassing, and it's not leaving it up to the insured owner to say if it's material or not. And then if the person has any exceptions, then they give them, hey, I went to the doctor for XYZ, or whatever. I felt ill, I had COVID, whatever. I mean, they could be saying this, and it's not being left up by number 3. I have not consulted or examined by a physician. If they have, they can put whatever it is there, and then the underwriter can determine if it's material or not. And it's very helpful at claim time when we know about delivery and when we have the affirmation about good health. One last topic, let's talk about reformation. This comes up in claim time, but it could also be, it comes up in death claim time. It could also come up at living benefit claim time. So a reformation is a remedy to change or correct. It can rewrite a contract so it reflects the intent or understanding of both parties. It can be used for mistakes, wrong amount, plan, or term. You know, hey, we added another 0 on, and instead of having $5 million worth of coverage, you should really only have $500,000. So we got to correct that, whatever. Used for misrepresentation. Both parties have to agree to the reformation, which is important. And what happens if one party doesn't agree? If one doesn't agree, then it could be a legal case. If one says, no, that's not correct. Okay, so we have to be careful about that both parties should agree to a reformation. Let's go through an example. This is a living benefit claim. It's a waiver premium claim. We have a $500,000 life policy issued on a 42-year-old male in January of 2023. Waiver premium claim was submitted in October, same year, for a disability caused by herniated disc. And it's a contestable policy. So as usual, a contestable investigation was done and revealed that the insured actually had a herniated disc in 2020 or 2022, for which he had surgery. Was not revealed. Okay, so now what do? You're going to send this contestable investigation to underwriting. Would underwriting have done anything different? I'm not an underwriter, don't play one on television, but perhaps they would have removed waiver of premium, considering that there was a back issue. Okay, what about claim? You have a living benefit. What would you do? You could reform. You could try to reform, saying, you know, okay, the life policy appeared okay. Waiver premium should not have been issued because of this misrepresentation. We're going to offer you a reformation in which we're going to remove waiver premium. And of course, you can't make a claim. If you are okay with reforming, you can keep your life policy. Okay, it goes back to the owner, and if they sign that it's going to be reformed, okay, waiver premium comes off and they keep the life benefit. If not, then it could be a legal issue because there's really no claim to be made when there was misrepresentation. You could try to rescind as well, but you have a life policy that might be okay. So more discussion would be had on that, but that's a case where a reformation might be presented because you have a disability that could have removed waiver of premium anyway. What about death? Okay, so this comes up a lot. All right, a $50,000 non-smoker life policy issued on 42-year-old male, January of 2023, died in October. But now we learned that the insured had a smoking history for the last 10 years and no indication of stopping. So sometimes we'll see medical records and the person will be smoking, stopping, began again, stopped. This one, nothing. It was continuously smoked for 10 years. Underwriting would have said we would not have issued a non-smoker policy at all, right? We would not have issued that as applied for had we really known that there was material misrepresentation. Person died. Can you reform it back to a smoking policy? So some carriers would, some carriers would not. Would you have two parties saying it's okay? A beneficiary was not the party to the contract. So there's much discussion to be had about reforming at claim time because you don't really have a meeting of the mind, but it's a way of paying a claim that it's not a whole rescission. You would reform it back to a smoker and pay a different benefit. Question is, can you do that? Can you really do that without having a meeting of the minds regarding that reformation when two have to agree to it? So, as I said, different carriers approach it differently. I'm just posing that to you. It's just a question for discussion. Okay, so let's recap. We went through the power of the application underwriting file, how it influences so many things, establishing a contract. We have to know what is needed and by whom. If you have no valid contract, you have no valid claim. We went through insurable interest, the public policy of insurable interest, and how we can't wager on someone's life. Policy could be void if there's wagering, if there's no insurable interest. We went through agreements, declarations, good health statements, however you want to call it, defines what requirements must be met to say the policy was enforced. Of course, we went through the temporary insurance agreements, how they could be a reduced benefit, but maybe it's not, doesn't have as many conditions as a conditional receipt, whereas you have many conditions. And we just touched upon, just in the last couple of minutes, some reformations on living benefits and possibly death claims, depending on the philosophy of the company. So went through a lot, and you can see how when we look at the application or underwriting file, it really influences what we're doing today when presented with a claim. And today, I mean, it could be during a contestable investigation, or it could be almost immediately before the policy is delivered. So when a claim professional is presented with it, always have to look back at the application, the underwriting file, see what is affecting our claim adjudication. So in closing, my theme was power. I'm sure you saw the images of power lines and cell phones and all that. So power is knowing your past. So in a claim file, yes, the power is knowing about what happened before. What did we know about before? What did the insured agree to? What was in the application? There is power in that so that we can go forward and adjudicate the files correctly and in the interest of how the policy was supposed to be enforced. All righty. So I have some time for questions. So Jill, are there any questions?
As of right now, there are not, but
Okay.
I do have a question. So I look at a lot of applications and temporary insurance agreements and conditional receipts for our client companies. Um, I don't see suicide a lot. Is that, is that more
Yeah,
of a current thing not having that on there, or is it just
I would
maybe
think it would have to be on there.
it just I very rarely see suicide as
Wow.
I mean, every once in a while when I do, I'm like, wow, cool.
Yeah,
So,
I would think so. I mean, and especially so Missouri, the state of Missouri, to enforce paying like a suicide benefit, when a person commits suicide during the successful period, you basically have to prove that they intended to commit suicide when the application was taken. So improve intent on that day, which is difficult.
Oh, so if
Um,
it's like, you know, a year and a half old, if you can't prove that they wanted to commit suicide with this thing, then it's not contestable,
and not for the suicide.
the
Now
suicide,
you
like
could look
other
at,
health or whatever.
yeah, material misrep, but suicide's tough to prove in some states because, as I said, Missouri, intent on the date the application was taken out, and
Yeah.
that's difficult. But suicide, I would think it should be on those receipts to
I
make
know
sure
you've said
you're
that before, but
covered.
it's just not. So I just wondered. So, when you have a change in health between application date and the policy issue delivery time, but you don't get a delivery receipt back from the insured, can you still use that as a reason for denial of a claim?
Yes, yes, if it's within the contestable period. Yes. So that's why I went through it so much with the language, right? So one of those policies didn't say it had to be delivered, right? So just issued in premium. But yeah, and I have relied on that because as I mentioned, an insurance company has to know the risk, right? For what it's worth, right? The application, they're signing that all these questions are answered true and to the best of their knowledge. Now a change happens and the insurance company's not in the know anymore. So should they be at risk for that? And I say no, it's not written for the unknown risk. So yeah, we relied on that. Yep.
Gotcha. And in regards to an insurable interest, if a company is domiciled, say in New York, but does business in multiple states, do you follow the rules from the state of domicile for the state the policy was issued in?
Ooh,
So I think that like say it's a New York company,
yeah. New
so
York.
they're domiciled in New York,
Yep.
but do you follow the rules from the state of the domicile for the state? Do you follow the state of the domicile where the policy was issued? So if they were issued in New Jersey, but the company itself is in New York, do you follow New York's or New Jersey? I think that's what they wanted to say.
Okay. Um, I I believe it's going to be issued where it's issued, but I would want to look at that further. I believe the statute states where like a policy issued in. Usually it states that. Very rarely does it say residence, but I would look. Um, where did I find that? I believe I found it at ACLI. There's a lot of information on insurable interest, but I can look at that further. But I believe it's issued where it's issued.
Yeah, generally, I think it is as well, just from an underwriting standpoint, that, uh, like there's certain laws, especially in New York,
Yeah.
that if they are applying in New York, they have to have certain laws. And in New York, a lot of times you can't, they frown upon you going to another state to apply and so that I would definitely know your compliance laws for the states that you're underwriting
Oh yeah.
because it can be confusing and ACLI is a good source for you to check out what the different compliance laws are for each state.
Hmm. For sure. For sure.
All right.
Anything else?
Then just confirm the exam requirements would have to be satisfied for the TIA to be valid, correct?
It depends on the language of that TIA. For the
That's what I
conditional
was gonna say.
receipt, for sure. TIA, maybe not. I mean, I mean, personally, if I was presented, of course, with an early claim, I'm going to ask for everything. Give me a copy of what they would have signed. Give me a copy of their TIA or conditional receipt. I have to see it because there could be that limit of the amount, and we all want to make sure we have a meeting of the minds how much of what the amount is that could be at risk. But it all depends on the wording, and some of
Yeah.
it does not state that it has conditional receipt has to be like all those conditions. TIA is almost it's I mean, all those four questions or three questions that I showed, they have to be answered. But I would go back to the actual agreement that there was to see if an exam would be required. Sometimes not.
Yeah, I agree because it's like, and every company kind of tweaks their receipts and their TIAs and everything with their own language.
Yep.
So, I mean, it's kind of hard to answer it depends on what your TIA says
Mm-hmm.
because your company might have put that in there, whereas some other company might not. So they are different for
Yeah,
lots and lots of different companies.
yeah, for sure, for sure.
And then of all the examples given, which scenario do you see the most commonly acts across carriers? All the examples given, which scenario do you see most commonly across carriers?
Of all the examples, I think probably the hottest topic I think is insurable interest because that still, we're talking about all the scenarios I gave. That is still an issue because of Stoli. And Stoli came about when 2007. I think they were really, well, I think the Kramer case was in 2007. We still see Stoli. We still see questions about insurable interest. We still see that. We still see policies being sold on the third market. So we still see that. So as far as like if we're talking about TIAs and conditional receipts, um, I think I see TIAs more than conditional receipts.
Yeah. I, we have all sorts of different companies that come in for pricing, and so I see all sorts of different kinds. So I could tell you from an underwriting standpoint. Um, is there ever an instance where fraud is suspected, but the death benefit is lower than the potential costs of litigation, loss of reputation, etc.? The carrier doesn't take up the opportunity to rescind or contest.
Oh,
So it's a $5,000 case, but it might cost you 10, 20, $30,000 to go to court for it.
I believe some attorneys would call that like a nuisance case, maybe. Have I seen it? Uh, yes, I have seen those. I have seen those when they're small face amounts.
And that's a carrier too. I mean, and that's what their policies are and what their thought process are. I mean, other carriers are like, no, it's fraud is fraud, but how much are you gonna
Yeah.
spend to prove that you're right?
So the one thing that uh, it's concerning when there is a small case that's fraudulent, like company A could have it, company B, C, D, and E could also have the same kind of situation, and somebody might be getting away with it, right? You might not know what other coverage is out there, and people are known to stack their insurance, go from carrier to carrier, and you don't know, and it could be small amounts like that. We have seen that happen.
Yeah.
Mm, yeah.
All right. Is there any other questions? If you do have any question, oh, what about reporting fraudsters? Why is the industry not collecting the info?
Oh, I don't know. Oh, we're not collecting it. I know certain states have, their regulations that they have to report the fraud. Now, what I've heard from folks that are, you know, in charge of fraud at whatever agencies, you're going to pick, what do they call, like the low hanging fruit, the ones that are going to get the most bang for your buck. Now, if you have a $5,000 policy and you're sending that for fraud, I don't know if that's going to be looked upon so quickly as you've got $500,000 fraud, right? I mean, you got to put your resources where you're going to get more bang for the buck. I believe direct carriers still have to report fraud in some states. So I'm not aware that they're not reporting.
So it's an individual state thing. So there's no like centralized depository of these, like, because like there's agent, um, basically agent database that says, this agent isn't the greatest kind of thing, but there is no centralized, this applicant or this insured is, that's the thing,
Yeah.
trying to get everybody to agree
And
as to who you report to and why. But yeah, if there's certain specific, would that be in the ACLI as well?
it might be. I'd have to take a look. Um, but yeah, you don't see things certainly in the news about a $5,000 policy, right? Again, more bang for your buck. If you're going to show fraud ring, it's going to be $500,000, $1 million, or whatever. But as far as I know, carriers still have to report fraud. It's up to the agencies. Now, what do they do with it? Do they see uh, any effects from it? I don't know.
I mean, and there's are few cases that you hear that, the police have been involved and there's several cases I know of in New York Um, and stuff like that. So it's like, those are big ones, and it was kind of like a ring
Yeah,
and things like that. But
yeah,
it could even be a reputational thing, even if you're right on a $5,000 case.
yeah,
Do you know what I
yeah.
mean? It's like,
Sure.
this big, huge insurance company is, denying, this grandma $5,000, even though she lied. So, I mean, that makes you look like you're a horrible person, even though they lied. So,
Yep. And different carriers have different risk tolerances for that kind of thing, for sure.
exactly.
They do. They do.
I
Mhm.
do. So, any other questions? If not, if you want to ask a question, you can always send it to us at info.us@optimumre.com,
Mhm.
and we'll get back to you. And then there is a survey at the end. Please, please, please fill it out, and then we will be sending out the PDF version of the presentation. And I really appreciate everything and everyone attending. Thank you.
Thank you, everyone. Enjoy.